Good afternoon, everyone. Welcome to Smart Talk. Thank you for joining us. This afternoon, we are joined by Liz Seghetti and Gunjan Agarwal, partners at Fox Rothschild, to discuss intellectual property. They'll be going over the types of IP that exists and why your company should care. They'll be covering trademarks, copyright law, patents, and more. All of this is crucial information for early stage companies to know so they can defend and monetize their intellectual property and to understand what investors are looking for when evaluating companies' IP. So as always, at the end of the program today, we will have time for Q&A. So at that point, we certainly invite you to come on screen if you have any questions or comments to share. And you can also make use of the chat function throughout the program, and we can get to your questions at the end. So really appreciate Liz and Gunjan coming on today to share their time and expertise with us. And without further ado, I will let them take it away.
Thank you for the introduction here. Sorry, just trying to start this. Okay. As mentioned, Liz and I are going to talk about protecting and monetizing your intellectual property. We will briefly go over different types of IP, what small companies should think about while protecting IP in terms of timing, what are the key points to consider, things like that. So why should companies care about intellectual property? It's often one of the most valuable assets that you have as a small company. It gives you exclusive rights in any intellectual property. You may know that even if you don't have your own intellectual property, others in the market can have their own IP that creates a risk for your company, and it can often act as a defensive strategy to protect your company from potential suits or as a bargaining chip while dealing with those companies. It also builds market value. Often in any due diligence, investors and lenders want to know what your IP is, and they want to know the value of your IP. And as I said, it's a defensive strategy. For example, if it's a tech company and you're working in a crowded area, having your own IP can give you a negotiating tool where you can exchange your IP with theirs, and so that and also protect yourself from potential suits. Liz, do you want to mention something about why companies should care about IP?
So I'm Liz Seghetti. I'm chair of the emerging companies practice at Fox Rothschild, but I'm also managing director and have been an angel investor through Delaware Crossing Investor Group for the past 16 years. So I'm here to sort of I'm going to be the sort of sub-presenter to add a few comments about the business and investor side of this throughout the presentation. When you are looking at this from a legal point of view, I would just encourage startups to think about this as one of the earliest things that they should invest money in, and not to skimp on this from a legal or business point of view. If there are times, as we will go throughout the presentation, when you can lose the right to protect your IP if you wait too long, or others can get in there. So it is one of the earlier things you can focus in often. And I'll be talking about our Fox Launchpad program later, which is a virtual incubator in the firm. We do offer a service to do a strategic plan for your IP moving forward from the start. And that's something that's really, really important to think about. And I guess the other thing is, I guess that's really it for now, but that is one of the most heavy areas of due diligence when you're going into early stage, seed stage funding, that the investors will look at. Delaware Crossing is now looking at this for multiple companies. Back to you.
So what are different types of intellectual property? It can broadly be classified into patents, trademarks, copyrights, and trade secrets. And I'll get into each of these in a little bit. But patents cover inventions, any novel ideas. Trademarks relate to a name or a branding that's attached to a product or a service that identifies you as the source of that product or service. Copyrights is any expression of ideas that's fixed in a medium, for example, a publication. Trade secrets are secret information that have some commercial value that your business derives from. I'm going to start with trademarks. As I said, trademarks are signs, symbols, brand names that basically attach to a product or a service and identify your business as the source of that product or service. A customer identifies you as that source looking at that trademark. For example, Apple, the A of Amazon, you know that the brand, that the Apple logo is associated with the company Apple. It could be a word, phrase, symbol, or even of sometimes device, for example, a logo that's attached to a device. It has to be used in commerce for it to be a trademark. And as I said, it identifies and distinguishes the goods or services that you provide. It generates goodwill and provides to a customer information about the origination of the goods or services. A trademark can last indefinitely so long as the mark is in use in commerce. What are the scope of trademark rights? They give you an exclusive right to prevent the use of similar marks in commerce and also to control your goodwill or reputation. And when I say confusingly similar, it can be confusingly similar in terms of pronunciation, spelling, or anything that creates confusion in the mind of a consumer that the source of the goods can be your business and versus someone else's business. For example, Apple, the company name, it's APPLE. Someone else cannot go and register a trademark that's APLE. Or APPL, because they sound similar even though they have different spellings. And that's the basis for looking at trademark infringement as well, likelihood of confusion as to the source of goods or services, and it connects the goods with a particular business. There can be different types of trademarks. It could be visual marks, example, words and logos. It could be a particular color, for example, a restaurant that's associated with yellow and black menu designs. A particular sound, smells, or product shape and trade dress. For example, a particular juice can that's conical in shape could be associated with a particular business. So it's not just limited to logos and words. You have to think about all of these different types of trademarks when you're thinking about applying for your own trademark or doing a trademark clearance. A trademark has to be distinctive. That is, it's not a descriptive term. For example, if you're trying to create music, if your business creates music or jingles, you cannot have a trademark that says jingle creation. That's a descriptive trademark. So when you're trying to think of a trademark that identifies your business, think about something that's not descriptive of your product or service. There are some trademarks that are often granted for descriptive phrases, but it's harder to get, and they're only granted when you've been using them for a long period of time and a customer has started using that phrase with respect to your business. For example, if you think of Google, it started off as a distinctive trademark, but has now become, can arguably, a descriptive name, because you don't say I'm searching the web. You just say I'm Googling. So think when you're trying to come up with a trademark, think of something that's distinctive, arbitrary, fanciful. Like no one would have associated Apple with devices. So that was an easy mark to obtain when they probably applied for federal registration. Versus if they had, if Apple had tried to go with a mobile phone or a FaceTime mobile phone type mark, they would have had a harder time with the US Patent and Trademark Office trying to register that trademark. A trademark can either be a federally registered trademark or a trademark that's obtained through common law usage. So, for example, you start using your company name in while providing certain products and services, but you haven't registered it with the US Patent and Trademark Office. You still have a trademark if you've been using it for a long enough period of time, but federal registration provides you certain benefits, such as it gives you nationwide priority and protection. Unless you have federally registered a trademark, you cannot prevent someone else from using the same mark. So you cannot just rely on common law usage to prevent other people from using the same mark. It creates presumptions of ownership, distinctiveness, and exclusive rights of use. Typically, registration, once it has been approved, lasts for 10 years, but you can keep renewing it as long as you're continuing to use it in commerce. It only expires when you stop using it in commerce. Also, be aware that you can only use the symbol R with a circle around it when you have a federally registered trademark. If you're relying on common law usage, you can use a superscript TM, but not the symbol R. If you have federal registration, you also show up in trademark searches. So for example, a second business comes up with similar goods and services. They're trying to decide on a name. They search for a mark. They don't find anything because you haven't federally registered it. So they're not put on notice because there is no registration and they can start using the same name. So going back to the first point, it does not give you a presumption of ownership unless you have federally registered a trademark. It can also be registered with the US Customs to intercept infringing imports from, for example, knockouts that are being manufactured outside of US and being imported into US. It allows you to take action against counterfeiters, which is not possible without a federal registration. And federal registration is not that difficult or expensive. Registering a trademark in a single class of goods and services is typically about $250 to $300 in fees, plus attorney fees if you're going that route. So it's one of the easier ways of building your own IP. So if you've decided on a distinctive trademark or a name or a brand that's associated with your business, I would recommend that you register it, do a search, and then register it. And I'm going to go through different steps of federal registration. First, as I mentioned, trademark infringement is you can take action against someone else or be sued by another business if you're using a mark that can create a likelihood of consumer confusion. For example, if you look at the marks here, Nike with Nike and Nika, Nikah. When a court looks at them or a consumer looks at them, they're looking at, will a consumer be confused if they look at these marks as to the origin of those goods and services? And or if it's causing actual consumer confusion. And that comes with, for example, the first example here, Monster Cable and the Monster mark. I cannot tell which mark is associated with which business. So that's actual consumer confusion versus likelihood of consumer confusion. Famous marks are also protected against dilution, and some examples are Coca-Cola, Apple, Google. They've become so famous that even though that everyone will know what the source of these of the products or services that have these logos are, and you cannot get similar marks allowed, like for example, an apple which does not have a bite. That's called dilution. So if you're trying to figure out a distinctive name for a trademark, here's a flowchart of what you can do. Create a potential list of names, evaluate the strength and enforceability of those names. Going back, strength, if it's a distinctive mark, not just a description of your product or services, it's strong, and as it gets closer to descriptive, it has lesser of a strength, and it'll have a harder time getting cleared by the US Patent and Trademark Office. In terms of enforceability, if whether or not it's going to create likelihood of confusion in the minds of a consumer. Once you have narrowed that list, you can do some screening searches. The Patent Office has a database called TESS, T-E-S-S, where you can enter your potential marks and see if someone else has a similar or the same trademark for the same goods and services. And I'm saying similar because, for example, with the example of Nike, if you just search for Nike, there'll be only one mark, but there might be similar sounding or similar close enough sounding or spelled marks. For example, N-I-K-I, N-I-K-E-Y. If you try to register any of those with the federal office, you'll probably get a rejection from the office. If you find similar sounding marks, then you'll have to go back to your list and find something else. You may or may not want to conduct a comprehensive trademark search. If you find something that's similar, you can come to us or any trademark attorney and ask what the likelihood is that you'll be able to get registration and be able to enforce those rights. Once you've settled on a name, you can file a trademark application that requires identifying a class of product or services where you want to file the trademark application, and then providing a brief description of those product and services. You want, in terms of the description, you want to be broad, but not overly broad, such that you cover goods and services that really don't relate to yours. In those cases, you'll get a rejection from the patent office, and you'll have to amend it. But it just means you'll have more costs associating with getting the registration in the back-end courts. Once you receive the registration, you can start using the symbol R. Until then, you can start using the symbol TM. Also remember, a trademark application can be filed with either an intent to use status or an actual use status. An intent to use is when you haven't been using the trademark with a product or services. And actual use is where you've already been using the trademark. If you do file the application with an intent to use, when the registration is granted, you have 6 months to file a statement of use where you'll submit some specimens showing, for example, a product or a website featuring a product that uses that trademark. So just to sum up, identify key product and corporate names, search for other marks that are used with similar goods and services. And remember, don't just search for exact matches. Consider phonetic similarity and words within marks. And what I mean with words within marks is if, for example, apple with 2 P's and apple with a single P. Apply to register significant marks on an intent to use basis. I should also note that you should reserve domain names, because those are also considered part of an IP, and if and when you go through due diligence, those can form a significant part of your IP portfolio. Liz, do you want to sum that up as well?
So sure. Also, it does take a little while to get a trademark, so don't think you're going to apply and get an answer a couple days later. I think, what is it, around 3 months now? Or and then if there's a problem, it could be even longer. So you do have to think ahead a little bit on that. There is some strategy to applying for a trademark as far as what industries to identify your trademark with. So a lot of people do this themselves and mess that part up. At least I've seen that happen in a lot of my startup and emerging companies. So, you know, do think about talking to an attorney first. Also, if you are having investors coming in soon, doing some sort of a search to get a level of certainty that you might get the mark, since it's going to take a while. And I guess the only story I can tell is, I know sometimes people are very worried about, you know, spending time and money on doing things like this, but I have had multiple clients who have hired marketing organizations and spent quite a lot of money putting together a marketing campaign, only to find out that the entire mark that campaign is centered around is not available, or getting, you know, letters from other companies telling them to cease using the mark. So it really does, it is really a good idea to do this ahead of time and know what you're doing, because you could waste a lot of time and money.
Thank you. I'm going to talk a little bit about copyrights now. What does copyright law protect? It's any work of authorship that's original and that's fixed in a tangible medium. And what I mean by fixed in a tangible medium is printed, or a movie, or a music CD that you have created, written a book about it, or a software that you have a source code of that's saved in a computer memory. In terms of works of authorship, it could be documents, images, mask words that relate to chip designing, music, video, anything. A few key things to know about copyrights: it only protects expression, so and not functionality. So, for example, with respect to software code, it only protects the code itself and not what the code does. For that, you have to apply for patents, which we'll get into a little bit later. Rights exist from the moment the work is created. So as soon as you put pen to paper or have recorded a music video, it's copyrighted work. You do not require registration unless you want to enforce it, and you don't need to register it right when the copyrighted work is created. You can register it anytime. It's typically owned by the author unless it's work for hire, which is described in the employment agreement or a contract with a contractor. So we'll get into agreements a little bit later, but things to remember as an employer is have that work for hire language in your employment agreements if you know that the employee is going to create certain copyrights. Duration, if it's a work for hire, it's 95 years from publication, that is when the copyright was created, or 120 years from creation. If it's not work for hire, it's life of the author plus 70 years. When is a copyright infringed? It's if someone else reproduces or distributes copies, prepares derivatives, uses it to perform a public performance, displays it, or digital audio transmission without fair accreditation and or without permission. Now, there are some fair use exceptions, which are typically non-commercial, but no, it should not create any harm to the market value. Fair use exceptions are very, very minimal. So I would just think about not using someone else's work rather than trying to figure out if your use falls within the fair use exception. In terms of registration, you can apply for registration, as I said, anytime after the work is created, but you do need registration if you want to file a suit against someone for infringement. When you register for a copyright, you have to publicly disclose the copyright and give a copy of the copyrighted work to the registration office. One important thing that is copyrighted is software code, but also think about, as a startup company, what is open source software code, and whether or not your own software code includes any open source software code. Open source does not mean free. It means that if you incorporate open source software code in your own code, you may have to publicly disclose your own code, even though you created it, you developed it. It refers to all of your own code, not just the part that links to the open source software code. So if you're planning to use open source software code, always check the license terms associated with that open source software code. There are certain licenses like the Apache and the BSD, which require that you must distribute your own code. There are other permissive licenses like GNU, Mozilla, that may require you to share your code depending on how you're linking with that open source code or how you're using that open source code. So it's always good practice to, before using any open source software, analyze the license terms. If in doubt, talk to an attorney, because it can be a very expensive exercise to rewrite your code or trying to figure out how it affects your license terms when you have incorporated open source software code. Investors and lenders, look at it very carefully. They will ask for a list of all open source software code that's incorporated in your products or services, and they will ask for licenses that are associated with that open source software code. If you don't comply with the terms of those licenses, you are liable for copyright infringement. So as I said, you have to be careful with respect to open source code. Have someone who is in charge of making a note of all open source code that your business is using. Require employees to get approval before use of open source code. Maintain a database and a listing of all code used. Keep copies of applicable license agreements. As I said, investors and lenders ask for this. They require this. Monitor compliance with these license agreements, and keep any open source code separate from your own proprietary code whenever possible. Copyright checklist, just things to think about. Obtain copyright assignments from all creators, includes founders if they're not your employees, and if you plan to reproduce or redistribute it, get an assignment from the owners. Don't use third-party works without a license. This includes open source code. Create and implement third-party open source code policy that works for your business, and keep an inventory or a database of all these licenses. Liz, do you have anything to add to this?
I don't think so, other than to emphasize the provisions in the employment agreement, which we'll talk about a little later. And also just a question, if you have some code, but you change it a little bit, is it still protected, or do you have to re-register?
You have to re-register depending on how big of a change it is. Again, it's copyrighted as soon as it's saved in memory. So you do have a copyright on the code. You don't necessarily need to register it. But if you are planning to bring a suit against someone, you will have to re-register the updated code if it's a new version.
And registration is not that complicated, correct?
Yeah.
It's pretty easy. Okay.
It's pretty easy. All you have to do is deposit the code and fill in the application.
Okay. Continue.
So moving on to patents. Patents are an important part of any company's IP strategy. That's because they showcase your technology. They're an important asset when you're looking for funding. They're a big asset when you want to block your competition from using selling products similar to yours or any modifications. If they can even be used to protect an area of research while you're doing your own R&D to identify a product. Patents are an important source of licensing revenue, and it stimulates innovation and economic growth by protecting investment. They are, as I said, very important in terms of investment, obtaining investment and financing for your small business. And investors often want to know, with respect to patent filings, what you're doing to keep others from copying your invention, and do you have freedom to operate? That is, can you sell your own products or services without infringing other patents? As I'll get into this later, you'll realize that these are two different analyses and two different things that you need to consider with respect to your patent strategy. A patent gives you limited property rights to exclude others from making, using, selling, or even offering to sell an invention that you have obtained a patent on. For obtaining a patent, you disclose to the public in detail your own invention and you get a limited monopoly right. However, it does not give you the right to practice the invention. That's freedom to operate and freedom from infringement that I'll get into a little bit later. It does not give you, while it grants you right to stop others from making or selling or even importing the invention that you have patented rights on for 20 years or 14 years, depending on the type of the patent, it, as I said, does not give you the right to practice the invention. So, for example, I like to take the example of a cheeseburger. There may be a patent that exists on the cheeseburger with a cheese patty and the bread combination. You get a patent on an improvement that includes melted cheese, some other condiments. However, you cannot sell that cheeseburger if the improved burger, if someone else has an initial patent on the cheeseburger, which includes elements of just the cheese between two bread buns, because your product also includes cheese and bread buns. So the patent you have received does not provide you freedom to operate with respect to the earlier patent that someone else has. So when an investor looks at your patent portfolio, they look at what patents you have received for protecting your invention from being copied by others, as well as whether or not your product or services infringes on someone else's patents. Should you apply for a patent? There are multiple factors to consider whether or not it's too late. For example, during your own R&D, you talked to investors, you went into business meetings, you talked about the invention that may destroy the novelty of the patent. Rating. Will the product provide a competitive advantage, and will the product be disruptive? What I mean by that is, will it create a scenario where it'll harm someone else's sales, in which case they may come after you, and having your own patent is a defensive strategy. When does a product provide a competitive advantage? I like to take the example of a phone having multiple graphical user interfaces. If you think a customer will like your GUI better than someone else's, then definitely apply for a patent to protect it, because it's easy to reverse engineer. It gives you the competitive advantage, and it can be disruptive to the current GUI producers in the market. The other thing to consider is detectability. Will you know if others are using it? The most common example is, for example, software that creates a map. There might be 30 different software algorithms that come up with that can create the same map. Now, how will you know if a potential infringer is using your software or someone else's software, when all you can look at is the map that's produced from a software? So think about detectability. If you think it's not going to be easy to detect whether someone is infringing your patent, it may not be worth it, worth the money and the effort to get that patent. Ownership. Are there third-party developers who are trying to, in the same space, who are trying to develop a similar invention? Then yes, apply for a patent because it'll protect your rights against those developers. Competitors' patent landscape. If your competitors are patenting their technologies, then yes, apply for your own patents, because there might come a time when they have independently developed a similar product or invention, and you may be blocked out from sending your own product or invention unless you have a patent on it. Also, if a competitor has, for example, 100 patents in the same space, you don't have any, you lose the bargaining chip if it comes to licensing some of their technology that you may need to use in selling your products and services. Also consider whether or not the product you're applying for a patent is patent eligible subject matter. Laws of nature and natural phenomena are not eligible. For example, chemical principles, mathematical formula, they're not considered patent eligible, even if you're using a computer for implementing those chemical principles, mathematical formula. But an application, a concrete application of such things can be patent eligible if you carefully craft the claims. For example, in the artificial intelligence space, there is a machine learning algorithm that is technically a mathematical implementation of an algorithm, but which by itself is not patent eligible. But if you're looking at a particular application, say, for example, autonomous cars, then it can become patent eligible. So discuss that with a patent attorney, how best, whether or not it's patent eligible. And there are certain gray areas where you have to carefully craft a patent application to make it patent eligible. What are different types of patents? They're provisional and non-provisional applications. Provisional applications are applications that you file mostly when you're in the development stage. You don't know what the final product is going to look like, but you do want to get a filing date. Some people also file it when they want to delay the costs associated with the patent process, because provisional applications are not examined for a year. However, provisional applications do not give you any rights, and they're not examined. All they do is give you a priority date and a 12-month time to file the non-provisional applications. The other types of patents are utility patents that protect the way an invention works. For example, if you look at a mobile phone, utility patents will protect the functioning of that phone. For example, how it rings, how it displays certain things, how it processes information. Versus a design patent is the ornamental appearance of that phone. So, for example, whether it's triangular, square, or rectangular with curved edges, that's covered by design patents. The graphical user interfaces are covered by design patents. Plant patents just they refer to food and agriculture patents that relate to plant reproduction. Patentability refers to whether or not your invention is new and non-obvious. New refers to no one has seen something like that in a publication or use or a patent before your patent application. And non-obvious is, again, going back to the cheeseburger example, a burger is known, a cheese bread is known, whether or not it's obvious to create a cheeseburger. The patent office may say it's obvious, so you create the application to list out reasons for why it would not be obvious. For example, the cheese melts when in a sandwich, but you have come up with a way to keep it as a slice form. then it's non-obvious. When must you file? As I said, patent protection is granted when when your invention is new and non-obvious, and disclosure can trigger loss of patent rights. The triggers can be described in a printed publication, you've offered for sale, or even gotten into discussions for selling certain inventions that can trigger a disclosure, or if it's otherwise available to public. It must be enabling, that is, a person looking at it can create the invention by themselves. File before any disclosures. In US, you have a 1-year grace period, but you don't have such grace periods in, for example, European countries and China. So best practices with respect to disclosures, create an invention disclosure form and keep it updated. Do not disclose proprietary information without NDAs in place. Don't disclose enough to enable someone else to make and use their invention. For example, if you go to an investor, talk about your invention, but in general terms. Don't tell them how you did it or make it enabling. When meeting it with a third party, set restrictions on materials. For example, collect any distributed copies, make it clear it's confidential. Do not enter into negotiations or perform any activities that can be construed as an offer for sale or actual selling. Keep good records and periodically educate employees about the value of IP. This invention disclosure form, I'm going to skip ahead. You can go through some of these slides about what to include. One thing to note is inventorship, and wrong inventorship can invalidate a patent. Unlike the research scenario or academia, where you want to list everyone as an author on a publication, a patent does not have the same inventorship criteria. An inventor is anyone who contributed to a claim of a patent and to the conception of the invention. So think about who should be named. Don't add additional people, or don't take out anyone who should be named an inventor. Inventorship does not, so if your inventors are often employees that are working on an invention, but that does not automatically give you ownership of the inventor. So have a carefully crafted employment agreement that grants you that ownership. It should not say the so-and-so employee shall assign any inventions that they come up with during employment. It should be they have and will assign an invention. If an employee leaves the company before or after a patent application is filed, but before a patent grants, get their address, get their contact information, get any assignments signed by them. Be proactive about these, because it can get into a situation where the inventor refuses to sign an assignment and you lose ownership rights. What you do when you get third-party cease and desist letters, don't ignore them. Restrict non-privileged communications. Pick up the phone and call an attorney. Don't write an email about, I received a letter, I think I might be infringing. Do not write any such things in memo or email internally or to an external party. If accused of infringement, contact an attorney immediately, and attorney-client communications are normally privileged. I'm going to skip over the patent application process as well. You can go through the slides and contact me if you have any other questions. As I said, provisional applications expire in 12 months. You have to file non-provisional applications, which are examined. You can also file a PCT application that gives you foreign filing rights. And the PCT application holds your place for 30 months from the earliest filing stage. So what to remember with respect to patents: get assignment agreements from all inventors, file patent applications before any disclosures. Before meeting with the patent attorney, complete the invention disclosure form and consider risks of third-party patents. Liz, do you have anything to say with respect to filing of patents?
Just really quick, I would say that when you're thinking about whether or not to file a patent, a lot of people have the impression that all investors want to see a patent or they won't invest in your company. They do want to see a patent if it will help you in your competitive posture or your ability to develop your product, but patents that have no use they take a lot of time and money. So really do a strong evaluation of your IP and what needs to be protected and what will really give you a competitive advantage. Otherwise, you might just be trying to be first to market, which that can work sometimes too, but everybody has different opinions about this.
Thank you. The final piece here is trade secrets. I'm going to differentiate confidential information from trade secrets. Confidential information is any IP that has commercial value and that's not in the public domain is reasonably protected. What differentiates it from trade secrets is it's valuable because the information is kept confidential. For example, the Coke formula, it's valuable because it's not disclosed. That's a trade secret. Versus any recipe that you have, that you've inherited from your grandma, but you're not commercializing, that's confidential information. That's not a trade secret. Why do you want to consider keeping a trade secret is because they can last indefinitely as long as they're not disclosed, versus all other forms of IP have limited period of protection. As I said, confidential information can be a large set of information, and trade secrets is a subset that's protected against certain state laws. What can be a trade secret? It can be any information that is not disclosed except under an NDA. It could be a formula, software code, business information, customer lists, any information. And that has commercial value due to its secret nature. You do have to show that you took reasonable efforts to protect secrecy to be able to assert trade secret protection. How does trade secret law work? It is protected by agreement and physical and practical implementation. For example, employees all understand their duties of confidentiality. All third parties sign NDAs, and you have workplace procedures such as key card entry, you have protections against cyber attacks, things like that. Duration, as I mentioned, it's unlimited while kept secret. Liz, do you have anything to add here?
So just a story, for example, I have a client right now at this very moment who is worried about their software code being stolen by employees who left. Turns out that one of the employees, instead of working on a company computer with, barriers and the ability for other people not to access that computer, had been working on his wife's personal computer and had developed the code on that computer. That is a big problem with trade secret protection. So you really need to structure your company so that the trade secrets are kept confidential within the company.
Thank you. So going back, what are your IP options? Patents, if it's a new technology, and as Liz mentioned, they're expensive, so consider carefully whether you want to apply for a patent. Copyrights, software codes, documentation, lab manuals, things like that. Trade secret, anything that's of commercial value and you can reasonably keep a secret. Trademarks, your brand names, your logos, domain names, things like that. Always value the pros and cons of applying for one IP protection versus the other. For example, if you're applying for patent, you have to disclose that information publicly for a limited monopoly right. But if you keep it a trade secret, you have to ramp up your efforts to keep it confidential, but you can keep it a secret for a longer time. IP ownership, different IP types have different ownerships. IPs are, for example, patents, as mentioned, are owned by inventors. You have to get an assignment agreement for a company to own them. Copyrights are owned by creators unless you have a work for hire type agreement. The risk is development by consultants, contractors, where you don't have that work for hire language. If there are multiple creators and developers of copyrights, then they become joint owners. Trademark rights are typically owned by company that uses the mark in interstate commerce. Remember, if you apply for a trademark before you form a company, then you as the individual own the trademark rights, you need to assign those rights to the company when the company is formed. Moving on, we just want to briefly touch on different types of agreements and what governs ownership of IP. So key clauses in agreements are assignment of inventions and copyrights, confidentiality, non-disclosure, and non-use type clauses. Always remember to sign the agreements at the start of an employment or consulting relationship. You don't want to be in a situation where an employer becomes hostile, is leaving the company, and you realize that they didn't sign an employment agreement that assigns rights to IP that they created. So always think about it before you get into a contractual relationship. Liz, do you want to say something here?
Yeah, there are representations frequently in investment documents about these types of agreements that they've all been signed by the founders. In addition, a lot of these agreements will have other things like non-competes and non-solicits that are not effective in some states if they are not signed at the start of the employment relationship. So that is incredibly important. These are very, very, very important documents and are one of the main things that are looked at by investors.
And always think about these agreements. As a company, you have a lot of other entities that you will do business with, have different relationships with, from founders, employees to investors. So always think about the agreement that you want to have in place, different clauses that you want to include, and different relationships that you want to protect here.
And I would just mention one thing: if any of the founders has a relationship with a university, that will also be looked at very, very carefully, because the university often claims rights to anything, especially a professor creates while working for that university. So you have to make sure that the license agreements or those relationships are very clear about what the company owns.
So we're just going to get into some agreement examples. Joint development agreements. For example, your company paid for it, but a researcher at a university is working on it. So you want to have ownership rights and IP rights in there. Creators retain ownership unless expressly assigned. Risks of joint and third-party ownership are sometimes you may not want ownership, but have a license. You have to clearly define the scope of the license, whether it's an exclusive license, whether the owner has the right to create field of use exceptions in there. So think about all of what you want from that relationship and have that embodied in the agreement. Does the agreement specify enforcement rights and obligations? Can the third party pull the IP away from you? For example, there can be scenarios where you start working with another company and that triggers third party to take their license away from you. So be mindful of what's included in the agreements, because that'll govern your duties and obligations with respect to the agreement. Licensing, and I'm going to turn this over to Liz from here. She's going to get into some other agreement types.
Yeah, I think I'm going to, given the time, I think I'm going to be incredibly general. I think the PowerPoint was sent around earlier, so some of the details can be sort of put through. So maybe if we go through this a little bit, the license agreement is one of the main assets. If you don't own your patent or own your IP, that license agreement will be given incredible scrutiny by any sophisticated investor. So it is very critical, and you really do need to have an IP attorney involved in that practice. So can we just go through and see if there's anything else here? So the NDAs, we've talked about that a little bit. This is very important for trade secret protection. They can be bilateral, where both sides are being protected, or one side's confidentiality information is being protected. It is very important not to have hidden provisions in these NDAs about IP ownership, or without really understanding what that is. I think, because we want to leave some time for questions, that why don't we just go through this? Keep going, because we have 5 minutes. And one thing to say about NDAs is they limit what the information can be used for that is disclosed to the other party. That's very important. It's not just that they can't disclose it to other people, it is what exactly they can use that information for. And that can be an incredibly important part of the NDA to define. So keep on going. Compelled disclosure in regulated entities. You know, what governmental disclosure is exempted from the limitation on disclosure. That is something. And I think we'll keep going. So we're on time. If it's already public, obviously, just like a trade secret, you don't have to keep it confidential. Or if it's disclosed from another source without an obligation of confidentiality. Going. You have to keep track of all your NDA relationships. It is an administrative task that is incredibly important. If you've disclosed, especially breaking trade secret obligations, you can really mess up your company, but I think we've already talked about that. So keep going. We've talked about this. Okay, be careful about that. This is an interesting, I don't know if you want to mention this, Gunjan, because this is something that's very particular to certain types of IP.
Yeah, so residuals mean trade secrets, which is retained by memory. So often when an employee leaves, they can claim that they retained it in memory, or if you were at a meeting, you want to, sometimes you may receive an NDA that you want to sign that requires these residual clauses. Be wary of these, and agreeing to such residual clauses may result in disclosure. You don't want someone to leave the meeting and say, I just retained it in memory and I'm going to use it later as a derivative or just whatever was disclosed. So be careful of signing NDAs that have these residual clauses.
Okay, so I think let's go to the Fox Launchpad slide. Okay, so we have a program at Fox Rothschild for startup companies, and it can be even a company that hasn't even been created yet, where we have a bunch of legal and non-legal, some free, some deeply discounted services for startups. And they include many of the types of agreements that we've been talking about today, the invention assignment agreements, the restrictive covenant agreements, non-disclosure agreements, all included, as well as formation, incentive equity plans, shareholder agreements, subscription agreements, and things like that. So feel free to check that out on our website. And we just want you to start out doing things the right way. And that's one reason Fox has invested in this program. So I don't know if there's a couple of questions. So we have a minute. Excuse me, I have a cough.
Thank you both. Yeah, if we have any questions, feel free to come on and ask away. But we did have one earlier from Adam Jones. It was during the trademark checklist slide. He'd ask, how do you search for smells and colors, etc.? I have comprehension of trademark electronic search systems in general.
There are some subscription-based databases where you can search for these. It's not easy to get hold of those. So I would recommend get in touch with an IP attorney, and then we can help with that search. Unfortunately, it's not an easy task to search for those. And some you may just be aware of. For example, if it's a fragrance, it creates value because it's in the marketplace and you may just become aware of it. Sometimes you have to search for it carefully.
All right, well, it is 3 p.m. So if there aren't any other questions, I think we're good to wrap things up here. Gunjan, Liz, thank you again so much for sharing your time with us. Really appreciate all of this.
Thank you.